In an IRS exam, the taxpayer always has a choice: represent yourself or use a qualified representative. Self-representation is allowed, but it can get risky fast when questions turn technical. On the EA exam, they love the simple rule: the taxpayer can always show up alone, but if they want someone else to speak for them, that person must be authorized and eligible to practice before the IRS. The workhorse document is Form 2848, Power of Attorney and Declaration of Representative. This is what tells the IRS: talk to my representative. If the representative is properly authorized and is an enrolled practitioner under Circular 230, the taxpayer generally does not have to attend the audit meeting. That's a favorite exam twist. Authorization plus eligibility can let the taxpayer skip the interview. Circular 230 is the rulebook for who can practice before the IRS and how they must behave. EAs, CPAs, and attorneys are the big three you'll see. But the exam also tests odd exceptions, like limited practice rights based on a relationship. So a family member can sometimes represent a taxpayer even if they're not an enrolled practitioner, as long as the IRS rules allow that limited representation. Here's a taxpayer protection you should memorize. If you're in an audit interview and you become uncomfortable, you can ask to consult a qualified representative. The IRS must suspend the interview and reschedule it to allow time to obtain representation. On the EA exam, watch for wording like "the auditor refused to stop." That's wrong. Once representation is requested, the interview gets paused. Joint return audits add a layer of logistics. If a married filing jointly return is examined, either spouse can meet with the IRS, or a qualified representative can meet with the IRS without either spouse present, if properly authorized. But representation is spouse by spouse. A Form 2848 signed by one spouse authorizes representation only for that spouse, not automatically for the other. Another exam favorite: the IRS generally cannot force a taxpayer to show up just because an interview is scheduled. Without an administrative summons, the IRS cannot compel a taxpayer to accompany an authorized representative to an examination interview. So if you see a question implying the IRS can require attendance in a routine audit setting, look for the summons language. Which of the following disciplined practitioners may represent clients before the IRS? The choices include a practitioner who has been disbarred, one who has been publicly censured by OPR, one suspended for 2 years, or the option that none of them may practice before the IRS. Think about what each type of discipline actually does to practice rights. The correct answer is Sophia, the practitioner who has been publicly censured by OPR. A public censure is essentially a formal reprimand, and by itself, it doesn't bar practice. The tempting wrong choice is none of these, because disbarment and suspension do prohibit practice, but censure alone does not. Which statement is not correct about changes to powers of attorney? The options cover substitution of representatives, revoking a power of attorney, delegating authority if specifically authorized, and a representative withdrawing from a matter after a power of attorney is filed. Think about what actions are required versus merely allowed. The incorrect statement is that a taxpayer must authorize a new representative when revoking a power of attorney. Revocation simply ends the prior authorization. It doesn't require naming a replacement. A tempting wrong answer is the substitution statement. But substitution does mean the newly recognized representative is the one the IRS deals with going forward.